The 6 topics we're going to cover are the 3 basic methods for buying a business, which Ray will address. And after that, we will participate in a little mock negotiation. Obviously, we can't cover everything related to structuring a deal, but Ray's going to represent the seller, Stephen. I'll represent the buyer, Brenda, and we'll look at purchase of stock versus purchase of assets. We'll look at non-competition agreements, representations and warranties versus an as-is sale, employment agreements, and methods of payment. Now, in order to help you out with some background information, we provided a term sheet for you for this proposed deal structure, and it's the sale of stainless steel containers, 20-year-old manufacturer with 2006 revenues of $4 million, EBITDA of $500,000. We just determined a sales price of $3 million using a 6 times multiplier on EBITDA. That's just due to current market conditions. That obviously can fluctuate. This company leases its plant from another company, so we have lease issues, and it licenses its technology from a Swiss company. Therefore, we have licensing issues, and the owner, Steve, is 60 years old, wants to retire. Brenda, who's your buyer, she's a competitor seeking to expand by acquisitions. She wants to keep stainless steel containers management in place. It's a small S corporation, so you have the flow-through taxation as opposed to a C corporation with the double layer taxation. And we're going to have issues related to a non-competition agreement, warranties and representations, and payment terms, which are to be determined. And now Ray's going to talk a little bit about the methods for buying a business.
I'm going to go through the 3 methods of buying a business fairly quickly here, and then when we get in the negotiation, you'll see to a greater degree how these work. We have Steve over on the left, who owns all of the stock in Stainless Steel Containers, Inc., and you can see all of the assets and the liabilities are contained within the corporate structure. Brenda has a bag full of money, and she wants to buy the company. In a sale of stock, which is method number 1, the transfer is very simple. Steve exchanges his stock certificate for the cash. As part of the deal, Marcus, as Brenda's attorney, will insist that all of the board of directors of Stainless Steel Container resign, as well as the officers. So since Brenda now owns all of the stock in the company, she can elect the board of directors, who will elect the officers, and therefore she'll be in control of the company. That's method number 1, sale of stock. Method number 2 is slightly more complicated, and it is a sale of assets. In this method, Brenda sets up a new company, Stainless Steel Containers Buyer, Inc., and capitalizes it by putting the acquisition amount within the corporation. A purchase of assets takes place at the corporate level as opposed to the shareholder level. And in a sale of assets, Steve will have Stainless Steel Containers transfer all of the assets over to Stainless Steel Containers Buyer, Inc. And let's say for this example that Steve decides he wants to keep the cash and the vehicles. One of the vehicles is a personal car, and also agrees to be responsible for paying off the bank loan. So the transaction occurs. All of the assets except for those 3 are transferred, and Stainless Steel Containers, Inc. has Brenda's acquisition price. There's a further step, though. There's no reason to keep Stainless Steel Containers around anymore because all it contains is cash and a car. So Steve dissolves Stainless Steel Container, Inc., pays off the bank loan. He has the cash from Brenda, the cash from the company, and the vehicles. And Brenda owns everything else. And if you notice, Brenda has even changed the name of her acquiring company to Stainless Steel Container, Inc., the same name as the name of the original company. So to the outside world, nothing has changed. In fact, Brenda doesn't have to change the stationery or the business cards or even the name on the outside of the building. But you know and we know that it is actually in a different legal entity. And then method number 3, I'll discuss this just briefly, and that is a merger. Let's say that Brenda's company holds other container businesses, and she wants to add Stainless Steel Container, Inc. as an unincorporated division. In a merger, the entire company, assets and liabilities, is folded into her company, Consolidated Containers, Inc. And as a result, the stainless steel container business is within that business along with her other container businesses. Now, there are 2 unique things about a merger. One is very good and one is very bad. The good thing is that if it's done correctly, it can be done on a tax-free basis, meaning that Steve will not pay any federal or state income tax on what he got from the merger. The bad thing is, as you can see in the slide, Steve does not have a bag of money. He has stock in Brenda's company. That stock is unmarketable stock. He cannot take it to a stockbroker and exchange it for cash. In fact, his only natural buyer would probably be Brenda. Now, if Steve is interested in being a partner with Brenda in the new company, that's fine. If he expected stock, then merger is not the way to go. Well, let's start the negotiations. I'll be representing Steve, who is the seller. If you get confused, Steve and seller begin with an S, Brenda and buyer begin with a B. So, Marcus, our clients have met. Steve has decided he wants to sell the company. Brenda has decided that she wants to buy it. They've done the hard part, which is to arrive at the purchase price for the company. So should we decide first how this deal is going to be done in terms of a structure?
Well, yeah, I think that's a good idea. Let's try to start with the overall structure, whether we're looking at a stock or asset type of purchase.
Sure. Lawyers, I think, oftentimes overcomplicate things. They make things far too complicated. I believe in the KISS principle: keep it simple, keep it short. So from that perspective, I would really advocate a sale of stock. Here's the stock certificate for Steve's company. What I'll do is I'll simply have Steve sign the back of it. We'll hand it over to you. That way you know that Brenda will be getting all of the assets and the liabilities in the company. We don't have to mess around with bills of sale or assignments of leases or deeds or anything else like that. Don't you think that this is the way to go?
I don't think so, Ray. There's really an issue here where the purchase of assets is better for Brenda the buyer. There's a lot of other things than transferring a stock certificate this way involved with a stock deal. You get a lot of the same paperwork and representations and warranties, but the purchase of assets is better because the seller's liabilities are not automatically transferred. We do want some liabilities, but we don't want all of them.
Well, what liabilities are you concerned about?
Well, we don't want to take over the taxes for the prior owner. Steve's got to be responsible for those. The employment claims, anything of that nature. What about personal injury and tort? Didn't I hear that a stainless steel container squashed a customer the other day?
That was a different company.
Hey, listen. It could have been a different company. Might have been something happened last year, 2 years ago. We don't want any part of that. Now, we do want to assume some liabilities. We'll assume the lease, the copier, the marketing agreements, the license agreements, things like that. But there's some liabilities we just can't take.
Well, even if you do an asset deal, there are some liabilities that are going to follow the assets. So this isn't, I think, 100% assurance for you. In any case, environmental liabilities, for example, will oftentimes follow assets when assets are sold. Employment discrimination claims, you'll be responsible for that. And even tort claims, product liability claims in some states will automatically follow the assets in an asset deal. That's not true in Illinois, but it is true, for example, in California and in Pennsylvania. Are there any other reasons why you're really stuck on a stock deal?
Well, just like with being able to pick and choose our liabilities, the purchase of assets is better because we can pick and choose the assets that we're going to be looking at. Some of the assets that we may want to take would be, or may not want to take, would include like the cash, because that's just an offset against the purchase price. The personal vehicle, personal office furniture, things of that nature, we really don't care about those, and Stephen, of course, wants to keep those things. And obsolete inventory is another example where you have a situation where you've got these rusted steel containers in the back that have been sitting there for 20 years. We're not going to take those. Stephen's going to have to dispose of those. And we'll discuss things like AR, the accounts receivable, whether or not those transfer or not. That depends on the deal structure and what works better with this particular company.
Well, there are two things that I think really augur for a stock deal. And when I tell you about these two things, I think you'll agree that stock is the way to go. The first is the lease. The company signed a 10-year lease, and we're now at the end of that lease term, and the rent is very favorable. And if we do an asset deal, we're going to have to assign that lease. Now, the lease says it cannot be assigned without the consent of the landlord. So if we go to the landlord and say, please consent to an assignment of this lease, what do you think the landlord's going to do? He's going to say, sure, I'll consent to the lease. here's your new rent. He's going to jack up the rent. Is that really in Brenda's best interest?
Well, yeah, it's okay. We've dealt with this situation in a number of deals before where you and I have negotiated with the landlord. As we know, landlord's consent cannot be unreasonably withheld in Illinois. Therefore, the landlord can't unreasonably withhold his consent. And even if there's a clause like the lease we have here that says it can't be transferred absent landlord's consent, even if it says in their sole discretion, Illinois law still provides they can't unreasonably withhold their consent. Brenda's got a strong balance sheet. She's been in this industry. I see no problem with getting that.
All that is well and good, but suppose the landlord says no.
Well, I've had that situation. I had it last year with a small company. Landlord said no. It was getting to push to shove. We were going to have to bring a lawsuit, but luckily we gave them all the information, the case law, and we're able to avoid that situation.
Well, our clients don't want a lawsuit. They want to buy and sell the company. So you're saying if we go that route, you may have to threaten a lawsuit. I don't think really that's in the mindset of either client. They simply want a business transaction here. But let's talk about the other item, which I think is even larger, and that is the technology license. This company cannot operate unless we have the technology license from the Swiss company. And again, that document says the license cannot be assigned without the consent of the Swiss company. Now, Brenda is a competitor. She knows the business. She knows how to manufacture stainless steel containers. I have every reason to believe that the Swiss company will consent to the license, but suppose they don't. You've blown the deal.
Well, the license agreement does provide that it's not transferable. However, that's probably not going to be transferable even in a stock deal. When you take a look at the agreement, and we'll have to look at it more closely, a lot of these agreements are like franchise agreements where the franchisor does not allow the franchisee to transfer the agreement, whether it's via stock or asset purchase. If there's a transfer of ownership or control of the entity, you still need to get the franchisor's consent. Most likely that's the instance here. So we're probably going to deal with the licensor in any event. Luckily, in this situation, Brenda is a strong candidate, has great financing, has great industry experience, and if we review this, get back to this later on after we've looked at the agreement more closely, I think we'll be able to work with the licensor in any event.
Okay, well, you made a good point. I think we have to check both documents to see exactly what they say about the consent to an assignment. Let's just talk briefly about tax considerations. Tax considerations oftentimes will dictate whether the deal should be done as a stock deal or an asset deal. I don't think that's true in this case. And let me tell you what my reasoning is, and then you can double check to see if you disagree. It's mostly because the magic words S Corporation, Stainless Steel Containers Inc. is an S Corporation and has been so since inception. Now, from Steve's point of view, as I see it, Steve wants two things. Number one, he wants the income from the sale to be taxed once and not twice. And number two, he would like that income taxed at capital gains rates, which are 15% as opposed to 35%. With an S Corporation, he can achieve both of those things if he sells assets or even if he sells stock because of the pass-through nature of the entity. Now, from Brenda's point of view, as I see it, Brenda would like a step up in the tax basis of the assets. The assets have been almost fully depreciated now. Brenda would like to take her $3 million purchase price, spread it among those assets, get a higher tax basis. Higher tax basis means greater depreciation deductions, means tax savings. And as I see it, Brenda can do that if it's an asset purchase or even in a stock deal if she makes a special tax election. Do you see it that way?
I think you're right, Ray, and I think this is one of the smaller issues we're dealing with here. If it was a C corporation, we'd be fighting like cats and dogs. We'd have to bring in some real heavy-duty tax analysis and tax advisors, accountants, and attorneys to really look at this and figure out how to structure it most beneficially. And I think a stock purchase would maybe be a little bit more likely in that instance.
Okay. In the term sheet, Marcus, you mentioned non-competition agreement. What do you mean by that? What's that going to involve?
Well, the non-competition agreement provides that Steve, as the seller, is not going to compete with Brenda, the buyer. We don't want a new competitor out there in the market. We want to take this company over the way it is right now, so Brenda's not going to be allowed to work in this industry. The geographic area is going to be contained to North America. We don't want her Steve working anywhere in North America. and probably we want it for a lengthy time period, say 10 years.
Why do you need a non-competition agreement?
Well, this really ties into what we're purchasing. We're purchasing stainless steel containers the way it is today. At this point in time, Steve is not a competitor. Steve is stainless steel containers, and therefore we want to maintain our customer relationships the way they are today. We want to keep that income source coming in. We want to maintain our employees. We can't have Steve soliciting the employees for some other enterprise, whether in this industry or a different one. We want to maintain the supplier relationships, those key agreements and contracts we have. And we want to maintain all our confidential information, protect the trade secrets that are in that company, and maintain the competitive advantage that we have. So these are things we need to address.
Well, you've made some really good points about a non-competition agreement. If you didn't have one, Steve could set up business the day after closing across the street, and Brenda would certainly have a valid gripe if Steve did that. But we'll go along with the idea of a non-competition agreement, but it has to be limited to some extent. Now, Steve is 60. He doesn't intend to retire, but he wants to keep busy in something. He's got a friend that operates a plastics injection molding company, and they make plastic containers. Do you have any problem if he works in that company?
Well, I've talked to Brenda about that issue a little bit, and plastics are not a competitor of the stainless steel, so I think that would be okay. We could allow that, sure.
Well, I should probably also mention the friend has a company that manufactures aluminum containers.
Oh, no. Aluminum containers are direct competitors of stainless steel. That's an area we can't go to. That's something where we definitely cannot allow Steve to go into that sort of an industry, because then he'd be able to use all of his contacts and business know-how to gain an advantage over Brenda, and we can't go there.
Let's talk about the geographic area. You said you wanted to limit competition in the entire United States. When we look at the customer base, though, 95% of them are located within 500 miles of Franklin Park. So you don't really need the United States, do you? If all of the customers are really located pretty much in the Midwest area.
Well, we might not need as large an area as we were talking about, but those other 5% of customers we definitely want to carve out for. And then the other thing we need to remember is Brenda's planning to expand. And a lot of times people don't look at those expansion plans in defining their non-competes, but we need to make sure that the expansion area is taken into account in defining the area of non-compete.
Well, I guess the case law does say you can go for an expanded area and still make it enforceable. But the last point, 10 years, I think you said, that's way over the line. Most non-competition agreements are more in the area of 3 to 5 years. And if you go to 10 years, the risk you take is if you try to enforce it against Steve, a court may throw the whole thing out, and you're going to have nothing.
You're right. 10 years probably is too long. Let's go with a 5-year non-compete. That is something that the courts have enforced in a buy-sell type of situation as opposed to an employment situation. So I think we would be safer going to a lower period and making the agreement enforceable.
Okay, the last point I just want to mention briefly, and that is allocation of the purchase price. If we do go with an asset deal, I want to go with either a no allocation or a low allocation of purchase price. When we allocate purchase price to a non-compete, it's bad from both sides. From Steve's point of view, it's ordinary income taxed at a high rate. From your point of view, you can amortize it over 15 years, which is a fairly lengthy time period.
Fine by Brenda either way.
Okay.
15 years either way.
How about representations and warranties? You said in the term sheet that you wanted Steve to make representations and warranties about the company. Why do you need that?
Well, we really want to check out this company, smoke out any problems before closing, and give Brenda a right to back out of actually following through with the closing if during due diligence something comes up. And then also the representations and warranties go towards finding anything out after the closing that was misrepresented as being true, and once again giving redress or recourse to Brenda the buyer if something's amiss.
Well, the term sheet said usual representations and warranties. What does usual mean?
Well, I just have a little list here of the usual representations and warranties that we go with.
I'm flabbergasted. Come on. You got like 30 things here. This is a $3 million deal. It's not a $300 million deal. You're going way, way overboard. We cannot it would take us days and days to negotiate all these out so they'd be acceptable to Steve. Tell you what, tell me which ones you absolutely have to have, and the rest we're just going to have to delete.
Okay, I see what you're saying. It looks like a lot that's there. But I represent Brenda. I need to represent her best interests, and there's a reason for each and every one of these. Because of our limited time frame today with negotiating, we'll have to take these up sometime later. But let's take a look at just a couple of these, just as an example. Okay. For instance, the financial statements. Those need to be true and accurate. Now, it may not be GAAP accounting principles because not too many companies use those, but we need a representation that they're true and accurate. The title to the assets. There cannot be any liens or encumbrances on these assets. We need to get everything free and clear of all liens. The purchase price needs to be used to pay off the liens. Condition of facilities. Brenda's taking over a new business. She wants to do a very good business. She wants to make sure that the facilities and equipment, everything is in very good condition. And then compliance with legal requirements. Let's take a look at that. Your guy's legal. He's very good. I'm sure he's complied with all laws and legal requirements. Therefore, we want a representation that says all laws and regulations have been complied with.
Well, Steve's reaction to this, as I said, I understood this to be more of an as-is sale than a full representation sale. I think this is really overkill. I have a suggestion, a really constructive suggestion for Brenda. And that is, I think rather than you and I spending a lot of legal time on negotiating these things, Brenda ought to be spending her money on due diligence. Look in all of the corners and all the nooks and crannies in the business. Look at the financial statements, the books and records. Check out the inventory. Check out the equipment. Talk to management. We may even let you talk to customers under a controlled set of circumstances. But that's the way to find out if there's anything wrong with the business rather than spending a lot of time on the legal stuff. And you mentioned the possibility of filing suit after closing. Litigation is the sport of kings. That's really not a very good solution for either party. It's a much better route, I think, is the look before you leap route.
Well, Ray, I understand that from a seller perspective, but we need to, protect Brenda here from my point of view. And this is not a used car sale. We need assurances that Brenda is buying what's been presented to her as a profitable business. And there are things that Steven says are true about this business, and we cannot just go on Steven's word. And when Steve says, oh, yeah, this is good and that is good, we can't rely on that. We need something in writing, and then we need to have some recourse if it's not true, including the ability to get out of the sale or after the sale to have a recourse.
Well, I do agree with you that some warranties and representations are called for, but if we're going to go along with your list, I want you to know there's some limitations we're going to be put on them. Like many of them, I think we will want to limit to the knowledge of the seller. For example, compliance with law. If I took any building inspector to any industrial building in Franklin Park, the inspector is going to come out with probably half a dozen building code violations. They all have them. Now, we don't have not specific knowledge of any, but you can't sue us for things like that.
Well, we can talk about that, but let's make sure we go to the best of Steven's knowledge, because I don't want him being purposely dumbed down and saying, oh, I didn't know because I didn't look. And so let's talk about maybe going to a best of sellers knowledge.
I could buy that. Buy that. And then we should limit the warranties and reps to just material things. For example, you said, I think, that you expected the condition of the equipment to be very good or excellent operating condition. So do you mean if a hand drill in the plant doesn't work, you're going to file suit? Hand drills aren't material.
No, I guess not. Yeah.
And then the last three I'll kind of combine all at once. These are basically limitations on the indemnification part. The right of Brenda to file suit and collect money from Steve for breaches of the warranties and reps. We're going to be looking for a basket clause, which is basically a deductible on the total amount of breaches. If you feel that the warranties and reps have been breached, you can't file suit until the basket is full, until you've reached a certain amount of damages. Second, we're going to be looking for a cap on total liability for breaches of the warranties and reps, so that Steve's liability cannot exceed a certain amount. And finally, a time period for making the claims. The statute of limitations in Illinois is 10 years, and Steve does not want to be exposed on those 30 warranties and reps for 10 years. On the time period, we're going to probably look for, maybe a year after closing.
My goodness. Well, let's take those three all at once.
All right.
With the basket clause, the deductible on breaches, we're going to take a look at that and try to figure out what a proper amount is. I'm assuming that Steve wants a higher basket than Brenda wants, because most likely the representations and warranties that will be pursued will be those of the sellers for
Right.
breach as opposed to the buyers. So that's something we need to talk about. As far as a cap on liability, I don't see any reason for it. We have a situation here. Steve has been responsible for the business before closing, and Brenda after closing. There's no reason for any kind of cap on liability. Steve's responsible for everything beforehand, Brenda afterwards. What do you say to that? But just give me 1 second here.
Sure.
As far as the time period for making claims after closing, the legislature, in its wisdom, determined that a 10-year time period is proper for breach of contract claims. I think that's fair. Now, I can see where you would want 1 year, and we can maybe look at negotiating some of that.
You made some good points in the abstract that Steve should be responsible for everything before closing and Brenda for everything after closing. In terms of a cap, 15 years ago, I would have agreed with you because caps were pretty unknown and very rare. But in today's market, because there's such a demand for good companies like Steve, sellers are dictating terms more and more, and caps are becoming much more common. The cap in this case would probably, I'd ask for maybe about 25% of the purchase price, $750,000.
No way. No way. We could talk 150%, something like that.
You want more than
one
the
and a half
purchase
times.
price.
More than purchase price, absolutely, yeah.
Well, what it comes down to with regard to the cap that Brenda has to realize, and that is this, that if Brenda won't accept the cap or a basket clause, then there are other buyers who will. And you have to put this in the total scheme of things. Is Brenda still getting a good value for her $3 million with these items? Because if she won't agree, there are other people who will agree. And ultimately, it's going to be up to Steve as to how hard he wants to press these points.
All right. Well, let's talk about them and get back on these.
Good. The term sheet also mentioned an employment agreement. Why would Brenda want Steve bound up under an employment agreement?
Well, I think an employment agreement is important, even in a situation where here Brenda's involved in the industry. Brenda has not been involved in this particular business. She needs some training in order to learn the business. She needs to be introduced to the customers, to the vendors. Needs to learn the procedures in the plant, get comfortable with the employees, develop those good relationships, and only Steve really knows this business, and we need some training of Brenda in order to make it work.
Well, to some extent, Steve is going to be flattered by that, by his importance in the company, and I think Brenda is wise to ask him to stick around afterwards to help with the transition period. But he's going to expect to be compensated under the employment agreement. Tell me about what you were thinking about in terms of what he would get.
Sure. I think it's important to keep the title and position the same in order to ease the transition and everything. So it's as seamless as possible to the customers and vendors. So let's do that. Let's set forth in our agreement the responsibilities as far as those introductions and employee relations and things of that nature, so we have an idea of what Steve's going to be responsible for, so there's not an argument afterwards. Let's talk about the time period, maybe 1 year with an option, something of that nature, things like that. Let's set that forth.
The time period with an option, 1 year is probably acceptable. I don't know about the option. But how about the fringes? Steve is very interested in the fringes. He'll ask me, am I going to get my health insurance? Am I going to have a car? Am I going to get my laptop, my cell phone, my BlackBerry, just as he has now?
All of those things sound fine, and clearly anything that's related to the business and related to his position, we'll keep him up with that. We're not going to go out and buy a new car for him. We're not going to go out and buy a Learjet for him, but we'll go ahead and keep the fringes as they are now.
Okay, I think that's doable. Finally, method of payment. That's why Steve is here. That's why he's selling the company, and this is the number one item to us. And in the term sheet, you had some really scary words. It said method of payment to be determined. Let me tell you what Steve's interest is, and that is cash at closing. Cash is king. That's what Steve wants. Now, if Brenda wants to go out and get a bank loan. We'll certainly cooperate in terms of getting the bank loan and try to convince your lender that this is a great company and definitely financeable. So please tell me it's going to be cash and closing.
I cannot give you that. And this is critical. We need to have some sort of deferred payments of the purchase price. The bank's going to want, and so does Brenda, for Steve, the seller, to have some, quote, skin in the game. He needs to have a vested interest in this company doing well over time. So if Brenda picks up the phone and says, hey, what about this? Steve is likely to answer and help out. And we want to have Steve putting as much effort into this company being a success in the future as he has in the past. And therefore, we're going to need some proportion of the purchase price to be deferred over time.
Well, what are you talking about in terms of numbers? What's Brenda going to put down? How much is Steve's note going to be?
I think the initial indications with the bank is the bank will finance about 70%. We'll have a down payment of 15%, and then we'll have seller financing under a note for another 15%.
Yikes. And how about the interest rate?
Well, I think banks are currently offering, 5% on CDs? So I think a 5% rate would be just fine.
Marcus, come on. This is not a CD. This is considered to be a much more risky loan than a CD. It's got to be prime plus something.
All right, we can talk about that. I think I could probably talk to Brenda about prime plus 1. You make a good argument there.
Or maybe prime plus 10.
Yeah.
We talked about the interest rate. How about the term of the note? How long will Steve be exposed for this? You said 15%, so that's about $450,000 if I did my math right.
Yeah, you're a math wizard.
Yeah.
Let me tell you, I think we're probably going to have to match up with the bank loan, which Brenda's getting a 5-year bank loan. Therefore, I think the seller financing should mirror that, and sometimes the financing entity, the bank, will require that.
And I assume that the bank is going to want Steve's note to be subordinated
That's
to
right.
the bank loan. So that means the bank gets paid 100 cents on the dollar. In case of a bankruptcy or a liquidation, the bank gets paid 100 cents on the dollar before Steve sees a penny.
That's right.
So there is some exposure here.
Yep. So, well, and then the other thing we need to talk about is we've got this deferred payments that we're talking about. But if something goes wrong, I want Brenda to have the ability, instead of having to come to you, or I should say your client, Steve, the seller, and say, hey, this equipment failed, you said it was good, it's not. Instead of coming directly to Steve for that $50,000, let's just make it easy and have a right of set-off so that Brenda can just set off against the payments she owes, just set that $50,000 off instead of having to sue and get that messy litigation going.
Well, I truly hate set-offs. I truly do, because now you're saying that not only is Steve not going to get his $3 million outright, he's going to get it $3 million less $450,000, and the $450,000 is maybe, because if you think there's something wrong with the company, you can simply deduct a payment. But unfortunately, legally, there's not much I can do in the documents. If I say you have no right to set off, we can put that in the note, but if Brenda thinks that something's been misrepresented, she's still not going to make a payment, and we're still going to have to file a suit. So if a breach happens, we may end up in court, and I'll have to inform Steve about that, and then he's going to have to decide on whether or not it's worth the risk. But if we are going to do deferred payments, our number one concern here is, and interest, is security for those deferred payments. At minimum, we're going to want a security interest in the assets being sold or the stock if we end up doing a stock deal. Okay. We're going to be looking for personal guarantees from Brenda to stand behind that note, and potentially other collateral, such as a second mortgage on a house, a pledge of a bank account. And I tell you, you can solve all of my problems on security if you just buy me a bank standby letter of credit. If Brenda has credit to get that, I'm happy, and we can forget about everything above.
Well, we'll talk about this, and I can understand Steve's need for security since Brenda owes some money, but I also want to ensure that Brenda is not over-secured. She has other business interests, other things she needs to use her credit for, so I don't want to use it all up here and have that all taken up. So that's something we need to talk about. After all, I hear she wants to buy a Lear jet next year.
Okay, so long as she can afford this company.
Okay. Now, the one other thing we need to talk about real briefly is we've got this right of set-off, but I really want some hard cash out there. And so I want to escrow part of the purchase price, put it in with an escrow agent. If there's a breach of a representation or warranty, then a proportion of that sales price, say 5-10%, and of the money will be taken out of the escrow or out of the purchase price, set into an escrow, and Brenda can tap into that when she needs to. And we should probably make this, it doesn't need to mirror the bank loan, but maybe go 1 to 3 years so there's enough time to make sure the company's running the way it's been represented to be running.
Marcus, you're making my life real hard here. There was nothing in the term sheet about a note. There was nothing in the term sheet also about an escrow. I suppose ultimately it's going to be up to the decision of the client as to how badly Steve wants this deal. But many people are confused about an escrow. They think if the money's put into an escrow and there's a breach, you get it out immediately. That's not how life works. You know and I know that if we put the money in escrow and Brenda thinks there's a breach, she'll send a notice to the escrow agent, a notice to Steve saying, I'd like some of that money. If Steve thinks you're wrong, there's not been a breach, we can send a notice to the escrow agent, which puts a brick on the money so you can't get it out. We end up in court, and the only way to shake that money out is one of two ways. Either Brenda and Steve agree on how it's to be paid out, or we get a court order on it.
Well,
so an escrow is not complete protection
I'll talk
for
to
Brenda
Brenda about it. I'll talk to her about it.
And it has some limitations there as well.
And obviously she's not going to try to dip into it for a minor thing. So that's one of the things we'll definitely talk about there.
All right. Well, we've gone through quite a few lists of things. I think we've come to some agreement on some items. Some items we have to look up and look at to see what the various documents say, and then other items we have to go back to our clients and see get directions from them on how we should resolve the various matters. So we've covered a lot of questions, and we want to see if there are any questions from the audience.
The question was whether or not there was any discussion about deferred payments in the term of an earnout, because earnouts are often a common item. That's something we didn't have time to go into in this discussion, but clearly where the future company's performance is based upon unknowns at this point in time, promises of new customers, things of that nature, a lot of times you will see earnouts structured in the sales price.
Caps are a fairly recent development, and there's not a lot of good data on what a good cap should be for a smaller company. The data I've seen was collected by the American Bar Association in the last couple of years, but it was really only data on public companies acquiring private companies. And the smallest deal in that study was, I think, 25 million. So these are fairly large companies. But that data indicated that a typical cap, I think, might be around 25% of a purchase price. Marcus is right. He argued for a cap on a smaller deal of the purchase price, or maybe something exceeding the purchase price. That would not be at all uncommon. And there's also many smaller deals where there's no cap whatsoever. So in representing the seller, I was pushing that, but that's not a point I would necessarily have won.
It doesn't make a difference on stock versus asset, because you're still dealing with the representations and warranties of the seller and what's true or not, and whether or not there's a liability limit on that. On the smaller deals, because the seller's only getting so much in a purchase price, often I'm finding that that's where the cap is, if it's even negotiated. A lot of times you'll see attorneys that don't know what they're doing in the smaller deal size in the Main Street and low mid-market that don't even raise the issue of caps. And if that's the case and you represent the seller, you need to make sure you raise it. If you're the buyer, more power to you.
The question was on accepting a limitation on the reps and warranties of knowledge. What's the difference between just getting the knowledge of the seller versus the best knowledge of the seller? And is there a significant difference in that?
And I think it really goes to the amount of diligence that the seller or the buyer, if the buyer is making a best of knowledge representation, puts into something. If you put in the language to the best of someone's knowledge, that indicates that there's been more done than just your actual knowledge. For instance, if I'm running a business and I maybe suspect that there may be a zoning violation with the building over here, I'm not even going to go and ask about that. That would be the sort of thing where my actual knowledge, I don't have knowledge of a zoning violation, but to the best of my knowledge would indicate that I would have needed to make some sort of investigation there And to the extent that I had some indication, there's a memo in the file that shows up later that says, hey Steve, do you think our building is in violation of zoning over here? Then that may be an indication that there was a problem there.
Yeah, there are all kinds of ways to slice and dice knowledge. Some contracts will create a duty to make an inquiry inside the company to find out if there are any breaches of the warranties and reps. The other thing I would insist on as Steve's lawyer is to limit knowledge to Steve's knowledge, what is inside his head, as opposed to the knowledge of the entire company, which can be interpreted to mean the knowledge of the janitor and the sales manager and everyone else. So the more limitations on knowledge, the better from seller's point of view.
And a lot of times then the buyer responds with, well, at least give me the knowledge of the higher echelon of management, because you can at least follow up with those people, give them all the reps and warranties, and try to find everything out that way, because due diligence is not going to find out everything, and you want to limit the surprises that you can after the sale.
The question is, what is the relationship between how much time you spend on doing due diligence versus negotiating reps and warranties? The due diligence is going to take a lot more time up front, but may save some time at the back end in terms of a quicker negotiation.
Yeah, and I think the negotiation on the reps and warranties won't usually take a ton of time. So really, your concern with regard to is the deal going to fall through if there's too much due diligence is a valid one. And if you represent the buyer, you want the deal to close. If you represent the seller, you want the deal to close, because you want a win-win situation. However, you don't want to shortcut the due diligence process, and therefore I look at the reps and warranties as a safety net to cover those things which you don't find in due diligence. As far as is there a set time frame for one or the other, I don't think there is, but I do think in order to make it a win-win situation, both parties should be diligent and really pursue it closely. I know Ray and I were both talking yesterday about deals we have, both of which have taken over a year just to get to letter of intent stage. So those are the sorts of situations where there's not a lot of impetus moving things along, and you don't know if the deal is going to close. Usually, the due diligence is important, clearly, because it gives you the reasons to walk away. But every horse has its spots, and you can deal with those if you know what they are. And the best thing is if the seller just provides full disclosure and says, here's the warts on the business, and then the buyer can deal with them afterwards.
Yeah, I'm a lawyer, and I certainly believe in contracts and in the reps and warranties. I think they are really important, as Mark has said, to smoke out problems. If you have a seller who has to personally sign off on those things, they're going to think a lot more deeply about the condition of the building and obsolete inventory, et cetera. But I also believe, and it's proved out by my experience over time, that spending money on due diligence is really a good expenditure. It's much better to know what the problem is before you buy the company than find out afterwards and then have a lawsuit you can file. Lawsuits are oftentimes not a very good solution. The question basically was, best of knowledge qualifiers are not necessarily in the seller's best interest. And what the seller ought to be doing is to be making complete and full disclosure of all items and really not insist on any types of qualifiers in terms of the representations and warranties at all. I certainly agree with that full disclosure is the key thing. If Steve were my client, I would tell him, look, anything that's bad about this company, Brenda deserves to know. And the reason it's in your best interest to make that public is it protects you from lawsuits or disappointments later. And there are always warts on every company. Even a successful company will have some bad things about it. But hopefully the buyer will be mature enough to look at the bad things and look at the opportunities there as well and say, well, although there's this risk and that risk, the opportunities far exceed what the bad sides are. So it was, I think, a really interesting question and a good remark.
It's a good point. In order to facilitate the deal, disclose. Make sure all the information's out there, and then if something comes up later, there isn't this big, oh no, what else is out there? This way, if everything's disclosed, there isn't anything that comes up later. You don't have those surprises, and you don't have the buyer wondering, what did the seller not disclose? So that's a good point.
The question was basically, is it wiser to forget about the materiality and knowledge qualifiers and to rely, in terms of representing a seller, on a basket? From a buyer's point of view, it may be preferable to eliminate those two qualifiers and then just quantify everything in terms of the basket clause and spend time simply negotiating that. Because that's one way to put it all into dollars and cents, as opposed to judgment calls on did the seller have knowledge, was this material or not.
Right, and certainly to the extent you can get the seller to agree to an unqualified representation and warranty, that's great. And as to the baskets and things of that nature and the tipping baskets, I'm a big fan of that as well, Terry, in that what that means is, say you have a basket of $50,000, you don't start at $50,001 by suing for $1, you sue for the $50,001. So there are definitely ways to protect the buyer there, and that's one reason why you see these negotiations with representations and warranties and indemnifications. They are complex, they do take time, and both attorneys are trying to represent their client to the best of their client's interest, and that's why sometimes these negotiations take longer than some people would expect them to right at the beginning.